I think you need to have weapons to take on the government. You need F-15s and maybe some nuclear weapons.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
We're gunned, we're outmanned, we're outstaffed. We do need responsible gun legislation.
Directly attack the issue at hand, and for me, it's very laser focused. It's violent crime in the metro.
We have the third highest gun-related injuries in the country, 90% higher.
Gun violence in this country is an epidemic, and it's an international embarrassment.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
Culkin versus Pritzker. Culkin versus Pritzker is like a legal thunderclap shaking up Illinois' gun laws. Picture this, a battle brewing over the right to bear certain firearms and magazines. It's like a high-stakes game of chess with the fate of Illinois' ban on attack weapons hanging in the balance. So, what's the deal? Well, it all started with Illinois imposing strict restrictions on so-called attack weapons and standard magazines under the Protect Illinois Communities Act, or PICA. But hold up, some folks weren't happy about this and said, hey, that ain't constitutional. That's where Culkin versus Pritzker enters the scene. This case isn't just any courtroom drama. It's a legal showdown aiming straight for the U.S. Supreme Court. These aren't your average disputes settled in a local court. Now, these challengers, they're not playing small. They've knocked on the Supreme Court's door, asking for a review. They want the big guns, the Supreme Court justices, to take a long, hard look at whether Illinois is crossing a line with these restrictions. Imagine the tension, the suspense. The whole case hinges on this crucial review. Will the Supreme Court give a nod to this case, saying, yep, we'll take a look at this, or will it brush it off, leaving the lower courts to sort it out? This isn't just about Illinois. It's about the rights of citizens, the power of states, and the interpretation of the law that affects us all.
We have the third highest gun-related injuries in the country, 90% higher.
If you were serious, you would acknowledge that 96% of mass public shootings happen in an area where guns are banned.
Directly attack the issue at hand, and for me, it's very laser focused. It's violent crime in the metro.
It's like a legal tug-of-war, and everyone's watching to see which side will gain ground. So why is this case such a big deal? Well, it's not just about firearms. It's about how we interpret our rights. It's about the boundaries between state and federal authority. It's a big, bold challenge that could send ripples through the legal world. That's Culkin versus Pritzker, a case shaking things up, asking the highest court in the land to weigh in on whether Illinois' ban on certain firearms and magazines passes the constitutional sniff test. Strap in, folks, because this legal roller coaster is just getting started. Illinois Attack Weapon Ban Challenge. All right, let's dive into the Illinois Attack Weapon Ban Challenge. It's like the hottest topic in the state right now. We're talking about this ban that's got gun owners and advocates fired up and ready to fight. So here's the deal. Illinois put the brakes on certain firearms and magazines, saying, nope, these are off limits. They did it through this thing called the Protect Illinois Communications Act. But you know what?
But at the crux of this is a bureaucrat making a unilateral decision to try to turn millions of Americans into felons.
Gun violence in this country is an epidemic, and it's an international embarrassment. The Second Amendment, from the day it was passed, limited the type of people who could own a gun and what type of weapon you could own.
Not everyone's cheering for this move. This ban, it's like a list of no-goes for certain firearms and standard magazines. It's a bit controversial because, hey, who decides which guns make the cut and which ones don't? That's the million-dollar question causing all this fuss. But wait, there's more. This ban isn't just about saying no to these firearms. It also throws in a registration deadline. Picture this, a clock ticking down to January 2024. That's the cutoff for gun owners to register these banned firearms they already have. After that, well, it's like the door slams shut. Imagine being a gun owner in Illinois, looking at this deadline, feeling the pressure to register your firearms, or else they become illegal. It's like a race against time, adding extra stress to an already heated debate.
Defund the police, and then they want to take our Second Amendment right to defend ourselves.
Getting assault weapons, AR-15s, out of the hands of people who shouldn't have them.
This rule
turns law-abiding gun owners into felons is a result of unelected bureaucrats.
Now, this ban isn't just affecting a few folks, it's creating waves across the whole state. People are questioning if this ban is fair, if it's stepping on their rights, and if it's even doing what it claims, protecting communities. It's like a countdown to a showdown, a clash between state laws and people's rights. The stakes are high, and everyone's got their eyes fixed on what's going to happen next. So, January 2024 is looming, and with it, this ban's fate hangs in the balance. Will gun owners comply, or will they rebel against this restriction? And what about the legal challenges? Culkin versus Pritzker is just one of the battles shaking the foundations of this ban. The Protect Illinois Communities Act. It's stirring up a whirlwind of debates, legal challenges, and tensions, all tied to which firearms should be allowed and who gets to make that call. It's not just about the ban, it's about the rights, the laws, and the communities caught in the middle. States' reluctance to defend, Supreme Court's role. Buckle up, because this is where things get seriously interesting. Illinois, the state at the heart of this whole ban on certain firearms, has dropped a bombshell. They're saying, we're not defending this ban unless the big shots at the Supreme Court tell us to. Can you believe it? It's like they're passing the baton to the Supreme Court and saying, here you go, you decide. They're washing their hands of this whole legal mess, leaving the fate of this ban dangling on the Supreme Court's decision. Now, that's not something you see every day, right? Usually the states rally their legal troops, lawyers, arguments, and all that jazz to defend their laws tooth and nail. But here we have Illinois saying, we'll sit this one out unless the Supreme Court drags us in. So, what does this mean? It means that the ball is squarely in the Supreme Court's court. They've got the power now, the power to decide whether this ban stays or goes, whether it's legal or not. It's like they're handed the keys to the kingdom of gun laws in Illinois. Imagine the weight of that decision. The Supreme Court has the authority to determine the fate of this ban, to make a call that could send shockwaves through the legal landscape.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
We're outmanned, we're outstaffed. We do need responsible gun legislation.
But here's the thing. It's not just about this ban. It's about setting a precedent, about how much authority the Supreme Court holds in these kinds of showdowns between state laws and constitutional rights. Illinois' reluctance to defend its own law is like a curveball thrown into the legal arena. It's a move that's raising eyebrows, sparking debates, and putting all eyes on the Supreme Court to see how they'll handle this unexpected twist. So, now we wait and watch. Will the Supreme Court take the reins and dive into this legal tangle, or will they let the lower courts sort it out? It's a chess game where every move has consequences, and the whole country's watching to see how this plays out. Background of the legal battle. All right, let's rewind the tape and dive into the roller coaster ride of this legal battle. It's like a drama series with unexpected plot twists and nail-biting cliffhangers. Grab your popcorn, folks. So picture this. It all started when a lower Illinois court, the underdog in this legal saga, stepped up and dropped a bombshell. They slammed the ban on certain firearms and magazines, calling it out as unconstitutional. Imagine the shockwaves that sent across the state. It was like fireworks going off in the legal world, with everyone buzzing about this groundbreaking decision. But hold on to your seats, because here's where things took a wild turn. Just when everyone thought they had it figured out, the Illinois Supreme Court, the big shots in the legal universe, stepped in and flipped the script. In a razor-thin decision, 4 votes to 3, they said, nope, ban stays. Can you believe it? It's like a legal roller coaster that had everyone gripping the edge of their seats. The lower court shook the foundation, calling the ban unconstitutional, and then, bam, the Illinois Supreme Court swooped in and said, actually, we're sticking with this ban. This isn't just any legal battle. It's like a tug-of-war between different courts with clashing opinions about what's constitutional and what's not. It's the kind of back and forth that makes you wonder who's got the final say in this whole shebang.
Change a law. They are already used to breaking the law, and the people will still do it, will continue to do it.
Weapons and high-capacity magazines in 3 communities in 3 different states in our nation. Enough!
The shockwaves of this decision rippled through the legal world. People were scratching their heads. questioning how such a closely divided decision could determine the fate of a law affecting so many. But here's the kicker. This wasn't just about the ban itself. It raised eyebrows about the judicial process, about how different courts interpret the law, and about the checks and balances within the legal system. It's not just a legal battle. It's a showdown between interpretations, opinions, and the power of the courts. Imagine the debates that erupted after this flip-flop. People dissecting the decisions, legal experts throwing in their 2 cents, and everyone wondering what this means for the ban, for the rights of gun owners, and for the future of similar laws across the country. So that's the background. A whirlwind of conflicting decisions, a lower court calling foul, and the higher-up saying, nope, ban sticking around. It's a legal cliffhanger leaving everyone on the edge of their seats, eagerly waiting to see what happens next. Concerns of judicial impartiality. The plot thickens with a twist that would make any legal drama fan sit up and take notice. Picture this. 2 judges on the Illinois Supreme Court, a court that's got a crucial role in deciding the fate of this ban, got a hefty chunk of campaign change from none other than the state governor. Cue the raised eyebrows and murmurs of concern. Now here's where it gets spicy. These judges weren't just casually sipping coffee with the governor. They were vocal about their support for bans similar to the one being debated in court. It's like they were already waving the ban flag before the case even hit the courtroom. Talk about a conflict of interest. Well, someone tried to hit the brakes on this whole situation by saying, hold up, these judges might not be the best fit for this case. A motion was filed to disqualify them from deciding on the ban because of these concerns about their impartiality.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
I think you need to have weapons to take on the government. You need F-15s and maybe some nuclear weapons.
But guess what? The plot thickened even more when that disqualification motion got shut down. The court said, nah, no need to step aside, and those judges stayed put, right in the thick of the ban debate. It's like a legal tug-of-war between concerns about fairness and the court's decision to keep the judges in play. People were scratching their heads, wondering how these judges, with their prior leanings and connections, could remain neutral in a case of such importance. This isn't just about this ban. It's about the public's trust in the legal system, about ensuring that decisions made in those high courts are truly fair and unbiased. It's like holding a magnifying glass to the workings of the justice system and asking, are we really getting a fair shake here? Arguments presented by petitioners. Oh, let's unpack the arguments these petitioners are firing up in court. It's like watching a legal fireworks display. Picture this. They're standing up and saying, hold on a minute, folks, these banned firearms, they're not just some fancy toys, they're tools used by law-abiding citizens. Their big argument? These firearms that Illinois is waving its ban hammer at aren't just sitting around collecting dust. No, they're saying these are commonly used for lawful purposes. It's like saying, hey, these are the tools of the trade for responsible gun owners. And then, bam, they drop the bombshell. This ban? It's stomping all over the Second Amendment rights. You know, that little piece of the Constitution that's all about the right to bear arms? They're waving that flag high, saying this ban is stepping on those rights like they're grapes in a vineyard. But wait, there's more. These petitioners aren't just stopping at Second Amendment rights, they're throwing in another curveball. They're saying this ban is creating a divide among citizens, a sort of haves and have-nots when it comes to gun ownership.
When someone does something to your family members that is illegal, we need to take them off the streets.
The Supreme Court said that the Second Amendment does provide an individual right to have a gun, but they said it was at home.
Have magazine bans.
Would the gentleman yield for a question?
The state of Florida, where we have freedom and the ability to carry whatever firearm we want.
Imagine being in a state where the law says you can have these firearms, but you can't. It's like drawing a line between who gets to exercise their rights and who gets left out in the cold. They're painting a picture of unfairness, of citizens being treated differently based on this ban. It's not just about the guns, it's about equality, about fairness, about whether a state law can draw lines between its citizens and say, you get this right, but not you. So these petitioners are making some serious noise in court, bringing up the widespread use of these firearms for lawful purposes, waving the Second Amendment flag, and calling out the ban for creating unequal treatment among citizens. It's a legal showdown that's putting the spotlight on the balance between rights and regulations. Impact of ban on Second Amendment rights. Let's dive into the whirlpool of how this ban is tugging at the heartstrings of Second Amendment rights. It's like a legal tug of war that's got everyone questioning the fairness of it all. So here's the scoop. This ban, it's not just about saying no to certain firearms. Oh no, it goes deeper. There's this ticking time bomb called a registration deadline.
Let me be clear, we all respect the Second Amendment, but it's not without limits. Imagine how much we could get accomplished.
Americans have the fundamental right to keep and bear arms that shall not be infringed.
Set to explode in January 2024. This deadline? It's like drawing a line in the sand saying, register your guns by this date or tough luck. Now here's where the drama unfolds. This deadline isn't treating everyone equally. It's creating a divide between those who can meet the deadline and those who can't. It's like saying, you got to keep your rights to these firearms, but sorry, you're out of luck. Can you imagine being in a state where your ability to exercise your Second Amendment rights depends on whether you meet a registration deadline? It's like having your rights vanish into thin air once the clock strikes midnight. This isn't just a ban, it's a line drawn in the sand that's creating two classes of citizens, one with rights intact and the other left hanging by a thread. It's sparking debates about fairness, about whether a state law should play favorites with its citizens' rights. And then, in a twist that's raising eyebrows, Illinois sends a letter to the U.S. Supreme Court, basically saying, we'll sit this one out unless you tell us otherwise. It's like a strategic move, leaving the decision-making squarely in the Supreme Court's hands. Can you believe it? Illinois, in this high-stakes legal poker game, isn't showing their cards unless the big shots at the Supreme Court ask for it.
By actually taking guns away from dangerous, violent felons.
In the filibuster, expand the court, take away your constitutional rights under the Second Amendment. Well, we just heard that that's exactly what the Democrats want.
It's a bold move that's got legal pundits scratching their heads, wondering what the Supreme Court's next move will be. So here we are, with this ban not just impacting gun ownership, but splitting citizens into two categories based on a deadline. It's a legal standoff that's got everyone questioning the fairness of it all. And with Illinois playing this strategic game of legal chess, it's anyone's guess what happens next in this courtroom drama. States notice waiving response. In the legal battle of give and take, Illinois just swirled in with a move that's turning heads. Picture this. Illinois, in the midst of this ban brouhaha, sends a message to the highest court in the land saying, we're kind of taking a rain check on this whole response thing unless you ring us up and ask for it.
With the kind of weapon that we will be voting to ban today.
Democrats to restrict Second Amendment rights, like requiring background checks for transfers of firearms.
Can you believe it? Illinois, in the ring with the big leagues at the U.S. Supreme Court, drops this bombshell, signaling that they're not exactly champing at the bit to drive into a response game unless the Supreme Court knocks on their door. It's like a strategic pause in a game of legal chess where Illinois is saying, we won't join the party unless the host sends us an invite. This notice isn't just a run-of-the-mill formality, it's a strategic step that's got legal pundits scratching their heads and wondering what comes next. So what does this mean? Well, it's like Illinois saying, we're not going to defend our law or present our side of the story unless the Supreme Court waves a red flag and demands it. It's a bold move that's got everyone speculating about the Supreme Court's next move in this high-stakes legal tango. This notice isn't just a legal footnote, it's a strategic move in this legal tug-of-war. Illinois is playing a waiting game, leaving the ball in the Supreme Court's court.
It is improper. You cannot ban weapons that are, quote, in common use at the time.
Does behavior change the interpretation of the Second Amendment?
Waiting to see if they'll request a response. It's like a pause button has been hit, leaving everyone waiting and watching to see if the Supreme Court will take the bait and demand Illinois to join the legal dance. The anticipation is mounting, the legal world's abuzz, and everyone's wondering how this strategic move will play out in this nail-biting legal saga. Anticipation of Supreme Court action. The anticipation is thick in the air, like a tension-filled courtroom before the judge's gavel strikes. Even though Illinois is playing coy and sitting back in this legal tango, there's a buzz suggesting that the Supreme Court might not let them off the hook that easily. Picture this. Despite Illinois raising their hands and saying, "We won't defend this ban unless the Supreme Court gives us a nudge," there's this sneaking suspicion that the Supreme Court might just do that. Give them a nudge. There's a history to this kind of move. Remember that NRV Naperville case? Yeah, it's like a distant cousin to this whole ban showdown. In that case, the Supreme Court asked for a response, showing their interest in the matter. Now, folks are whispering that history might repeat itself in this legal drama. It's like the Supreme Court is peering over the fence, seeing what's cooking in Illinois, and saying, "Hey, we might just want to take a closer look at this ban, whether you want to defend it or not." The legal pundits are placing their bets, saying the Supreme Court might just summon a response. And the buzz is that it's not just about Illinois, it's about the broader issue of these firearm bans and the Second Amendment rights at stake.
But, Madam Speaker, guns have been prevalent in the United States of America since before our founding.
And all those cases, he's going to list maybe hundreds more, they involve guns that are not banned by this.
So while Illinois is playing this strategic game of wait and see, the Supreme Court might just throw a curveball and demand a response. It's like they're not letting this ban slip under the radar without some serious consideration. This anticipation is palpable. It's like everyone's holding their breath, waiting to see if the Supreme Court will step up and take a closer look at this ban, just like they did in similar cases before. The legal world's on edge, waiting for the next move in this high-stakes game of legal chess. Historical precedents and future expectations. In the grand theater of legal battles, the Supreme Court's role is often akin to that of a cautious maestro, preferring to let the lower courts set the stage before stepping into the limelight. Traditionally, they've upheld a practice of non-intervention in the early phases of cases, preferring the lower courts to lay the groundwork and present a clearer picture before their grand entrance. Yet, nestled within this tradition lies a case that's turning heads, one that's stirring whispers of a potential divergence from this norm. Enter the Illinois ban on certain firearms and standard magazines, a legal tangle that's not just a routine skirmish between state law and individual rights. This ban is a complex web, spun with threads of constitutional significance.
All those laws now vulnerable to legal challenges.
In other states for criminal acts, and those who have stated a desire to get a weapon to do harm.
And societal impact. The Supreme Court, historically averse to early intervention, has played the waiting game, content to observe the legal battles unfold from afar. Their preference has been to allow the lower courts to grapple with the intricacies before considering whether to step onto the stage. But this time, it's different. This time, the ban's complexity and the stakes involved aren't just catching the eyes of legal scholars. They're flashing bright signals that maybe, just maybe, the Supreme Court might deviate from its usual script. Let's dive into why this case has piqued the interest of legal pundits and court watchers alike. It's not just another run-of-the-mill legal scuffle. This ban isn't merely about a state's law versus citizens' rights. It's about the bedrock of the Second Amendment, about the division between those who can exercise their rights and those left behind by a looming registration deadline. This ban creates a divide, slicing through the population, drawing a line between those who might retain their rights and those who risk losing them when the clock strikes on that January 2024 deadline. It's not just a ban, it's a fundamental question of equality and fairness under the law. Traditionally, the Supreme Court prefers the dust to settle before they enter the arena. But this ban battle, it's raising eyebrows, prompting whispers that maybe, just maybe, the court might intervene earlier than usual. The complexity of the issue and the fundamental rights at stake paint a different picture. Legal experts are murmuring that this might be the case that leads the Supreme Court to break its tradition of cautious observation. The implications are too weighty, the ramifications too significant to simply wait and watch from the sidelines.
I look at the New Jersey that I grew up in. I did not grow up in a New Jersey where people were carrying guns on their hips.
And on the table, you could pretty much say that falls in the category of a slip.
It's like a magnetic pull drawing attention to the Supreme Court, inviting them to consider an early entry into this legal showdown. The usual playbook might need a rewrite this time, given the complexities and the potential impact on constitutional rights. The anticipation is palpable. Legal scholars are analyzing past precedents, trying to read the subtle cues that might signal a change in the Supreme Court's approach. Everyone's holding their breath, waiting to see if this ban battle will be the one to nudge the Supreme Court off its traditional path and onto center stage earlier than expected. In this realm of legal uncertainty, one thing remains clear. The Illinois ban case isn't just a routine legal squabble, it's a potential game changer, a catalyst that might just prompt the Supreme Court to rewrite its playbook and take a leap into the legal fray sooner than anticipated. That's all for this video, folks. See you next time.